allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, welcome to the Town of Riverhead Planning Board meeting. Today is Thursday, November 4th, 2021. We're going to start with two public hearings tonight. But before that, I see we have some, I believe, students from Farmingdale State College, Mr. DeLuca's class, so I just want to welcome you to our meeting tonight. Hopefully you have a good experience, learning experience. We do have a full agenda, so you picked a good night to come. Okay, so the public hearings, the first public hearing we have is for Breezy Hill draft environmental impact statement.
Good evening, Mr. Chairman and members of the Town Planning Board. Good evening, Mr. Chairman and members of the Planning Board. My name is Phil Malicki. It's M-A-L-I-C-K-I. I'm a senior planner with the firm of Nelson Pope Voorhees of Melville, New York, and I'm the preparer of the draft environmental impact statement, which is the subject of tonight's hearing. With me is Tom Dixon from Nelson and Pope, who's responsible for the site plan, and the project's attorney, Mr. Stephen Lasquadro. The following is a brief history of the seeker history of the application. Site plan application was for the proposed concrete crushing facility was submitted to the planning board in June of 2017. In December of that year, the town chief building inspector determined that the project was not in accordance with town zoning code, as the proposed use was not in conformance with the industrial A zoning district in terms of allowed principal uses. The applicant then resubmitted the application in January of 2018 to seek relief from that ZBA decision by means of a variance. The site plan application remained pending at this time with the Town Planning Board, pending resolution of this issue. In the meantime, the Town Planning Board, as seeker lead agency, declassified the action as unlisted under the State Environmental Quality Review Act. That was in March of 2018. After determination by the building inspector regarding the proposed use was now permitted in the industrial A zoning district, the applicant appealed the determination to the ZBA, and on April 12, 2018, a determination was made that that the use would be permitted. This interpretation was confirmed by the ZBA clarification letter dated October 1st of 2018. Now, this history is covered in detail in the draft environmental impact statement. And Mr. Lasquadro is here to answer any questions that the board may have on this issue. Now, the Town Planning Department then completed their review of the site plan application in the form of a staff report, which was dated May 9th of 2019, which recommended to the Planning Board that a positive declaration under seeker be issued. This would require the preparation of a DEIS. The Planning Board conducted its coordinated review under seeker, and on May 16th, assumed lead agency status, issued the positive declaration. Now, in response to the positive declaration, the applicant prepared a draft scope of issues for the DEIS. Following a period of review by the town, a public hearing was held, and a final scope was prepared actually by the town and was issued on February 25th of 2020. The DEIS was then prepared to conform to the issues and items and categories of impact that were specified in that final scope. We prepared the DEIS and submitted it on December 30th, the year 2020. Based on the town review, the DEIS was deemed not complete and it was returned to the applicant for revisions in February of 2021. We revised the DEIS accordingly and resubmitted it in August of 2021. The second review was conducted by the town, and the revised DEIS was deemed complete and sufficient for public and agency review on September 2nd of this year. Now, SEQA required a publication of this determination in the environmental notices bulletin. That was done on the September 15th, 2021 issue of that document. Now, the DEIS was then available for public inspection at the office of the town clerk, at the town planning department, and at the Riverhead Library. The DEIS conforms with the final scope, as I mentioned, and includes a project description, existing and proposed conditions concerning topography and soils, water resources, ecology, land use and zoning, transportation, community services, community character, and other required sections that are specified by the state law. The full DEIS should be reviewed for complete information on the project and its potential impacts. Now, the applicant and the team are here tonight, as I mentioned, and to hear public and agency comments on the DEIS, and with the town, will determine the substantive comments to address in the form of a final EIS, which with the DEIS will form the complete EIS for the application. The FEIS will incorporate the draft EIS by reference and will be the basis on which the town board will prepare its own finding statement, and it will be on this document that the town planning board can and will base its decision on the application. Now I will turn the microphone over to Mr. Tom Dixon, who, like I mentioned earlier, had prepared the site plan application and the site plan.
Good evening, Mr. Chairman, members of the board. For the record, Tom Dixon with the firm Nelson & Pope, offices located at 70 Maxis Road, Melville, New York. I prepared the site plan that is part of the subject application. The property is located at 1792 Middle Road in Calverton. The property has frontage on both Middle Road and Manor Road. The adjacent properties to the east and west are both zoned Industrial A. The proposed site plan is for a concrete crushing facility. All existing structures on the property will be removed with the exception of the former residence. This structure would be renovated and converted into an office facility, and a new parking area is proposed for the office as well. The site plan indicates the location of the rock crushing and screening equipment in the northern portion of the property near Manor Road. Trucks will enter the property from Manor Road, circulate in a counterclockwise movement. There'll be a truck scale located near the office facility. The trucks will then dump the unprocessed material in the location shown on the site plan. The unprocessed material is then loaded into the crusher and processed and sorted into separate piles shown on the site plan. The trucks are then loaded with processed material and then exit back onto Manor Road. Measures such as rumble grates, truck washing would be in place to prevent tracking onto the roadways. The site plan does comply with all the bulk requirements and the town's parking requirements. The existing natural vegetation in the southern portion of the property, along Middle Road and adjacent to the existing residential use to the southeast, will all remain. And then additional evergreen plantings are proposed along the east, west, and northern property line along Manor Road, as indicated on the site plan. Drainage is proposed to contain all stormwater on site in accordance with the town regulations. The sanitary system for the office building would be upgraded to meet the health department regulations. During construction, erosion control measures would be put in place to contain any sediment, as well as dust control measures during construction. That concludes the applicant's remarks on both the DEIS and the site plan, Mr. Chairman. I would turn it back over to you to conduct the meeting, receive comments on the DEIS, unless you have any questions for myself or the project team.
None for you, but for our consultant, we do have a couple questions, and I think he has a couple statements for the record, and then we'll get to the public comments.
Thank you,
So,
Mr.
thank
Chairman.
Jeff, so the last time you came to the board, I think it was it September 1st? When was
September 2nd.
September 2nd, your memo was dated the 1st. There were a couple issues that we had noted, that we had questions on. On page 2, there was a printing error. There was some excluded figures. Was that taken care of?
No. on both the online version and the paper version that I have, and I believe you're referring to, in the Part 360
Yes.
application permit, the specifications, the cut sheets, if you will, of the types of equipment were not included. There is a description of the types of equipment within the text, but those sheets are missing.
Okay, and the DEC order on consent, the email from 2018 with the no permit, is there anything new on that?
There's nothing new other than I had gone to the site prior to the September meeting on August 23rd to do a visual inspection. I returned again on November 1st in preparation for this hearing. The Materials Management Division email had stated that all solid waste materials, both processed and unprocessed, everything on the site must be removed from the site within 120 days of March 5, 2019, for the approval of the remediation plan that was required under the notice of violation and consent order that was, I think, in 2017. So that material is still there. Typically, when that material, and actually within the consent order, when that material is to be removed, it was to be taken out at a rate not less than 300 yards per week, together with on-site documentation and record keeping. New York State DEC has two types of Part 360, a Part 364 transporter registration that must be carried by any trucks that would have come in to take the material out, together with a Part 360 series document, which is basically a full-scale bill of lading that explains what the material is, the quantity of the material removed, where it was generated from, what the characteristics were, and where it went to, and that's all signed off. That information actually was not included in the EIS. I'm requesting that be prepared and included, at least in the FEIS, and perhaps we can get some enlightenment as to what the status is on compliance with the DEC order on consent. Do you have other questions?
No, but it looks like there's
Well-
something else you want to say.
Well, yes, and that's simply because under SEQR, as the lead agency, you really have the oversight for all of the other involved agencies. So this particular project, which is a C&D processing facility, it's regulated under Part 360 of the DEC regulations. It's also regulated under not just 360, but different components of the Part 360 regulations. And you're sort of held with a responsibility to take a look at the regulations during the SEQR review process and determine whether or not, just as you were acting on behalf of the DEC, the project is in compliance with those requirements. If it were not in compliance with the requirements, did not meet their standards, then that would by itself create an impact because it would be inconsistent with the standards that the state has set. Very similar to water quality issues or wetland issues, it's just, in this case, applied to solid waste.
Okay,
Just a quick question, Jeff. A while back, you had mentioned with the solid waste management plan, they had initially tried to get the one from, was it 2020, and that wasn't available. Was there any change in that?
Yes, the applicant actually included the draft updated current solid waste management plan for the town in the appendix and did refer to it in the August 21 DEIS. However, be mindful that the planning unit that is described within the local solid waste management plan really just looks at the waste generated within Riverhead and primarily by the residents of Riverhead. So we looked at sort of the needs and benefits aspect of this project as to what is driving the need for this. Is it a component that is compliant with recycling efforts to take in a waste, which, remember, a waste is anything that is discarded because it's no longer useful for some other purpose that it was originally intended for. So if you're deconstructing a building, if you're tearing apart a road, all that debris would be brought to the site, and until it's processed, it's considered a solid waste. In this case, that volume would be 13,000 cubic yards of total waste unprocessed, and if it's processed, another 13,000 yards of processed waste for a total of 26,000. So we wanted to know where did that fit in with respect to the needs of the town, and to determine whether or not this waste was coming in only from Riverhead, but it is described as coming in from Nassau and Suffolk, with 75% imported by contractors other than the owner of the site.
Is the pond an issue anymore?
I looked at the pond. That really is a man-made pond. I didn't have an issue with it. There is I point out to the applicant a statement that they made in the Part 360 engineering report that there were no surface waters, but it's sort of a surface water, but it is man-made. So another component in the application is stated that it is within the Riverhead Water District. It is not in the district. I asked the Frank Mancini, the superintendent of the district. It's outside the district boundary. So there is neither infrastructure or district boundary to provide infrastructure to the site to provide Riverhead water.
Jeff, is the pond showed on any wetland maps, DEC or CAC?
No. The pond is really surrounded with sort of a little concrete. It looked more like a fish pond at one time. There's really no wetland vegetation to sort of tie it into the ecology. It did have water in it, but that may simply be runoff that had been contained there.
Jeff, there was some noted groundwater contamination found from the 4 monitoring wells. Just 2 questions. We had asked last time, what were the depth of those monitoring wells? And 2, has the source of that contamination been identified?
I can answer that the source has not been identified. I'll let the applicant, I don't have it in front of me if he wants to respond to the total depth of the monitoring wells. There is an on-site drinking water well that I asked in my comments why that was not included in any, groundwater sampling or analytical tests to see what the status of the on-site well was. I'm curious to know whether or not that well has to be redeveloped or enlarged, since that's the only provision for on-site water. And I'd like to see how that factors into fire protection.
Okay. We'll let him come back up in 1 minute. But just one other question. Has it been identified, once the materials would be recycled, what happens to them? Are they sold after that?
Well, the applicant says that they intend to use, I think the word they used, primarily use the material for themselves, and anything that they didn't use, they would sell. Within my comments, and I'll submit them and make them available. I ask, is there any supporting information on the quantities that they currently use or expect to use? Typically, New York State DEC likes to see that there is some contractual arrangement when you're processing this type of material. So the real purpose here isn't to just tip it there, leave it there, and process a little bit of it and use it when you need it. The real goal within the state solid waste management plan is to take in this type of C&D material and process it, and get it back out to a marketplace that's going to use it. So if it's being sold to contractors, and this opens up another series of comments, and it was stated that the material would not be available for retail, would not be sold to the public, but it would be available to contractors, even in a limited amount. I'm wrestling with the statement that they said it's not a retail operation, and they made a statement that it's not wholesale. And my concern is, well, if it's not A and it's not B, I'm more interested in knowing what C is, because I can't really render a determination as to whether or not a special permit is required. In the Industrial A zoning use district, all wholesale businesses are required to get a special permit. While we're on the topic of approvals, they also didn't list the requirements that they need to seek at the end of a site plan process, a Chapter 229 excavation and grading permit. They have proposed a cut and fill, which results in 9,000 cubic yards of material to be exported. So based on that cut and removal of material, I mean, they would have to get a excavation and grading permit anyway, but they should be made aware that the town board, which regulates the issuance of that permit, in the code has the requirement that a soil monitor be assigned, that there's a charge, a $2 charge per cubic yard for exportation and importation of materials. I was thinking a little bit earlier today that under the Industrial A zoning use district, you're only permitted 2 acres. In this case, they've shown that they're going to use only 2 acres, or a little less than 2 acres, for outside storage. So my question is, if the vegetation is remaining intact, if the detention ponds that were originally, or detention swales that were originally part of their Part 360 permit, which is still in there, they've now converted in the EIS and the site plan over to subsurface drainage systems, leaching pools. So they've taken out the detention area in the EIS and the site plan, but they didn't take it out in their permit application to DEC. Those are generally beneficial because you can go in and clean out the sediment in these, swale areas relatively easily. Maybe not so much when you're using catch basins and leaching pools. But beyond that, will the majority of the footprint of the 9,000 cubic yards to be exported be within that 2-acre area, where the majority of the material will be stored and processed? If the buildings and the vegetation that's out there going to remain intact, they didn't footprint for me where that was, and I didn't detail the grading and drainage at this point. Perhaps they can provide that, or we can look at that during site plan.
Okay.
Jeff, at our last meeting, one of the questions that we had was the pile that was there. We were concerned as to what was the makeup of the pile. Did we ever determine what was in that pile, where it originated from?
I don't know where it originated from. According to the DEC record, which is cited in the appendix of the EIS, in the consent order, it does talk about a July notice of violation that was issued, and a cease and desist order, which, the way I read it, it appears that the material was being processed on site, as well as not just stored there, but actually under a processing operation, which stopped at the issuance of the violation. However, the conditions of the consent order, as I said before, required the preparation of what we commonly call in our work a cleanup plan, which you submit to the DEC. You'll take samples, discrete samples, analyze it for, its chemistry of the soils and things to see what's in it, which they had done. And then any materials that don't meet certain standards have to go to an approved disposal site. I think there was 870 yards or thereabouts that did not meet what we call the beneficial use threshold, which meant the contaminants level were too high for, to be used even if it were an approved processing facility and they wanted to ship it out. But I didn't see any record, that had been done. But still, it remains within the content of both emails and components of the consent order. Everything on the site is to be removed. And that, to me, would make sense, because if you had a permit to process it, that material that was below the threshold of contaminants could be processed, but they don't have a permit to process it. So I guess the DEC determined if you wanted to take that material to a processing facility that had a permit, it could be processed. But you would still need to track through the DEC's tracking documents to verify that had been done. Also in the FEIS, I've made some recommendations that if this were to move forward, all of that information that would go to the DEC on a regular basis, all that transport information, where the waste came from, where it went to after it was, had been brought in and processed, et cetera. Any testing, DEC has testing standards for the soil to determine whether or not it meets that quality standard. The town should be made a component of that material in the future in order to, since the DEC is getting copies of all this, you would, I would think, want to have an assurance that you had it as well. My main concern is any soil brought to the site. There's an area for 5,000 cubic yards of soil. Any leachate that might be generated out of that soil could leach to the groundwater, which is, I think, in the area compromised to some degree. And there are drinking water wells in the area because it's outside the water district. While we're on that topic, DEC requires the location of all wells, both private and public, within an 800-foot radius of the property line for this type of facility. And they did identify public drinking water wells, our wells, but they didn't put in the private wells in the area. So I'd like to see that in the FEIS as well.
There were public wells within 800 feet?
Well, they have a diagram of a map. They didn't they located the wells within the area. I think they put in maybe plant 11 and maybe another one, but whether they're 800 feet or not, they're shown in a graphic, okay, but the private wells are not shown on that graphic.
Okay. Did we discuss the hours and days of proposed operation, number of truck trips per day, whether it was going to be anything on weekends and noise?
Okay, so I've actually been making this statement since the 2020 DEIS was submitted. So let me go over it in detail for everybody. In the original EAF that was submitted for this action, it was listed as the hours of operation are Monday to Friday, 8 a.m. to 5 p.m. In the DEC Part 360 permit, it describes the operation of Monday to Friday, 6:30 a.m. to 6 p.m., Saturday, 6:30 a.m. to 5 p.m., Sunday, 7 a.m. to 2 p.m., but dumping only, no processing. The traffic section on page 340 describes the hours of operation as Friday, Monday to Friday, 6:30 to 5:30, Saturday, 7 a.m. to 7 p.m., Sunday, 9 a.m. to 12 p.m. The sound level measurements, and this is important because sound was one of the key topics, Monday to Friday, 6 a.m. to 8 p.m., Saturday, 6:30 to 5 p.m., and Sunday from 7 a.m. to 2 p.m. And in the sound section, it states that the proposed project will limit operations during these hours as part of their mitigation. But I think when I did the worst-case scenario, it was 7 days a week with as much as 14 hours of operation. If the applicant is really using this material for his own purposes, and he's got complete, or they have, just being generic, the applicant has complete control of the site, the hours of operation can be tailored to those needs. The main, probably one of the louder and vibration-oriented pieces of equipment that Dave described can actually process by crushing the concrete at a rate of 450 ton per hour. So when you kind of looked at all 13,000 cubic yards, convert that to tons, et cetera, you could do the entire storage in 3 days, 4 days, if you ran it, pretty much on an 8-hour day. Obviously, that isn't going to happen, but I don't see how I can evaluate what the impacts of the hours of operation are on the residential areas, because I can't figure out which one applies.
Okay. Before we bring up the applicant back up, do you have anything else you want to share with the board, Jeff?
Just, well, on the traffic, I noticed that the turning movement counts were done on January 30th, 2020 and February 1st, in order to pick up weekday and weekend. I think they need to adjust this to take a look at Splish Splash and its operation at the signalized intersection of Manor and 58, 25, whatever. I know that Splish Splash, during that seasonal time, is pretty busy. I think they probably have a traffic or parking management plan themselves, but I don't think that those dates are necessarily representative of other seasonal traffic impacts when we're in full swing out here with Tanger, Splish Splash, and maybe other operations. They had also asked the planning department if there were any other proposed projects in the area. They didn't have any listed. I don't know what the status of the lavender farm is these days, but maybe if there's any other update the planning department can provide them on projects that they see in the foreseeable future, I think that would benefit the applicant's traffic engineers to take a look at that as well. There was a section, again, going back to the DEC permit. I apologize, I don't mean to be flipping back and forth, but as I said earlier, as a lead agency, you really have the umbrella spread out over everything, and your responsibilities really are to cautiously look at everything under that umbrella, whether it's a DEC permit or a site plan or a local building code that you have a concern about. And that really is what qualifies it as a hard look. I don't think we've received comments yet back from the DEC. I don't know what the status of their application is. So you're actually assisting the DEC in the review of that. But it did state on page 25 in their summary that the applicant for the proposed facility seeks to obtain a permit to allow for the processing of C&D materials as well as mulch, in accordance with the requirements outlined under subpart 361-5, which is the C&D processing facility section of the DEC regulations. The summary further states, quote, "This report provided a description of the facility, surrounding environmental and regional resources, as well as operations as they relate to transfer station activities." Transfer station is not a permitted use within the industrial A zoning use district. The section further states, quote, "Pending approval," meaning the Part 360 approval, "the facility will operate as a construction, demolition, handling, and recovery facility that accepts concrete, asphalt, rock, brick, and soil for processing of mulch and RCA for sale." So I think that needs to be re-examined. There were no other sections that, in the impact statement itself, that addressed mulch. If that's the direction they're going, then we may have to look at a supplemental EIS, or at least embellish greatly on that in a final EIS. And I think that might be it for at least a last summary comment. My research indicates that this area is within an environmental justice area. The applicant's research has suggested that the nearest environmental justice area is actually located in Southampton, but I believe we're right in nearly the center of such an area, and that will need to be revisited and substantiated.
So, Jeff, I mean, you just mentioned processing of mulch with the soil. I mean,
Yes.
did we even talk about or require looking at any smells or odors from mulch facilities?
As I said, that was not in the context of the EIS. I don't know why that's in their Part 360 permit. They didn't identify where it would be stored on the site plan. I can't answer that.
Okay.
As I said, my obligation is to literally go through this document inside and out multiple times, look for any inconsistencies, as well as it's an impact statement. A statement is to be factual, period. So anything that does not look like it is referenced or substantiated, even if it is a misstatement by error, it has to be identified and cleared up before you can move forward with accepting an FEIS and moving to a finding statement. Because if that, let's say that were to remain, and you do a finding statement, and it results in a positive finding statement, meaning that there were no, all the impacts have been mitigated or avoided, the project can move forward, that permit could be issued that way with the wording of the mulch in it and the soil, and you would not be able to maybe back out of that because the DEC and the applicant would hold that in the permit. But we didn't study it, so I don't want to miss that. And if it's just simply a misstatement that was included, then it's got to be cleaned up. If it's not, then it's got to be, explained in greater detail, because I have no further information other than those two sentences, including the one on the transfer station. I don't know where that came from either, so.
Okay, thank you.
You're welcome.
So before we get to the public, maybe the applicant can come back up and answer a few of these questions that we have outstanding here.
I can only say that the information that was in the impact statement was provided from the Part 360 permit and from the, work that was done separately to prepare the environmental impact analysis and things like that. The fact remains that if mulch is mentioned in the Part 360 permit, that was an error. I've spoken with our attorney, and that was never intended to be included in the project whatsoever.
Okay.
And it, as I said, it will be removed. For the issue would be straightened out for the FEIS. Question about the differences in the operating hours, that will also be corrected and made consistent between both the Part 360 permit and the impact statement. Details of the other comments that Mr. Seaman has provided will be addressed in the impact statement in the FEIS, which will straighten out these issues and all of these inconsistencies.
Okay, and we spoke about selling the material that's processed. I think there's a question, if it's not retail or wholesale, what is it going to fall under?
That, again, the details of that will be determined. Extensive discussions, obviously, with the applicant and straightened out between Part 360 permit and the impact statement in the form of the FEIS.
Okay, do you recall the depth of those monitoring wells?
I do not know. We did
no.
not investigate that for the impact statement. But we will now. But
How come the piles haven't been removed?
that would have to be determined from the applicant. I have no information on that issue.
Okay. All right, so at this time, we're going to invite anyone from the public who has any questions or comments to please come up, just state your name for the record, and we'll move on from there. Anyone from the public have any comments or questions? Please come on up. No one?
Good evening, Talcott Church and President of Calverton Civic. I have some notes here. So the reason for my attending tonight is to bring to the attention of the planning board, our Town of Riverhead Planning Board, whom we depended to protect our land use. Calverton has been, as you know, a target of quite a lot of industrial projects, seemingly all at the same time, looming to land in 11933. I would ask that you keep in mind Calverton Civic wrote a very detailed letter September 9th or 10th of 2020, submitted it to the town board, asking for a moratorium, just a pump of the brakes, nothing severe, just something to be able to understand, educate, understand, and decide how we'd like our hamlet to be configured. And as it happened, within a month, the comprehensive plan kicked off. So that's a year ago. We're not done with the comprehensive plan. A project such as this, with the intensity of use, is something that needs to be looked at, and our residents need to weigh in on it. Not just simply here in front of the planning board, but in the sense of a comprehensive look at all things that are going on as land use, not only in Calverton, but also in the rest of Riverhead. And we're right in that process. So I would ask you to be mindful of that letter. If you'd like me to provide it to the board, I'd be happy to. So when looking at the report that was prepared for today, the aerial photos depict land use beginning in 1947 when it was wooded with improvements surrounding it was farmland to the west and north of the 1700 block of Middle Road. It was sectioned into residential lots, yet to be improved, with the exception of the corner property, Manor Road and Middle, where there was an existing home. So 1962 aerial of Middle Road, of the residential sites had homes. Industrial use on the west side of Middle Road was as yet undeveloped. Property across from these homes was still farmland and wooded lots. By 1984, industry was digging into the sand at the foot of the road, closest to Middle Country Road, Route 25, yet the farmland persisted and the homes had been developed and families were living there. By 2001, by the 2001 aerial industry had creeped in. And my question is, will industry be allowed to continue to creep, or will we take a responsible approach to this, a comprehensive look at the industry and the intensity of use with this project that with this look that you're doing tonight on this report? There is no mitigation by the applicant of noise, truck traffic, compromised air quality, water quality, that will maintain the quality of home life these folks who have made this section of Middle Road their home, raising children, grandchildren, hoping to experience the peaceful enjoyment of their homes day and night. It's for this reason, plus the other 7 industrial projects taking aim at Calverton right now, that GCCA created that letter, and we ask that you either request a letter or take a relook at it, because our hamlet and our town is currently under an intense attack, it seems, and we want to be able to shape our hamlet responsibly. Thank you very much.
Thank you.
Excuse me, miss? This is a public hearing. If you want that letter to be part of the record, you probably should resubmit it.
I'll happy to do
Because
that.
this is a public hearing.
You could give it to our secretary or email it in.
Sure. Electronics good? Yeah, I'll have it done
Yeah.
by the end of the night. Thank you.
Thanks. Okay, anyone else from the public?
Good evening, Mr. Chairman, members of the board, ladies and gentlemen. My name is Barbara Blass, and I live in Jamesport. A lot of the comments that I was going to make were covered by Mr. Seaman's very thorough presentation, but I will highlight some of them again. Sale of materials needs to be categorized. Wholesale facility would require a special permit by the town board and make them an involved agency. Hours of operation clearly are all over the place. Chapter 229 permit would be in order if they are exporting 9,000 cubic yards of material. That also would make the town board an involved agency, and that required permit should be listed in the EAS, not the EAF, the DEIS, the final. I do have some additional information on the environmental justice area. The DEIS does describe an area 1.8 miles to the southeast of the subject site in the town of Southampton along the Peconic River. It says the banks of the Peconic River. As you know, I follow the solar applications pretty carefully, and I remember seeing a depiction of environmental justice areas in the 94C application submitted by Riverhead Solar 2. I actually printed out that map, and I unfortunately didn't bring it, but I will submit it to you. There, the environmental justice graphic contained in that application sits completely around or on top of this site, and I will provide that if you want to look it up, or the applicant wants to look it up yourself. It is figure 28-1, item 86 on the data master of the 94C application for Riverhead Solar 2. Regional facility, the DEIS states that this is not a regional facility, but the document does clearly provide or describe that 75% of the materials are coming in from private contractors from all parts of Nassau and Suffolk, so I'm not sure how this is not a regional facility. I know the applicant is not bound to provide any additional information that was not outlined in the scope, but as the lead agency, I was wondering if you would be able to provide information on the gross quantity of material that's already coming into the site to the identified 7 existing solid waste facilities. There are permitted, there are registered, and there are retired sites that are still operational. There are 7 of them, and they're all taking in and processing material. And I think it would be a good figure to know what's already coming into the town.
Is that town-wide, Barbara?
It's within the town of Riverhead. But the material is coming from elsewhere, obviously. So, but all of those 7, and actually, to speak to Ms. Turchin's point, they're all located in Calverton.
All 7?
All 7. Violations. The DEIS does contain information about prior violations. And it says, in fact, to ensure that no further unauthorized material will be accepted on site, the document states, quote, "Facility staff, including equipment operators and laborers, will be trained to identify acceptable waste and to report unacceptable waste to the facility manager." Respectfully, considering the violation history, is this self-policing adequate? More importantly, visual inspection is not sufficient to determine the presence of leachable contaminants. Water, I'm not going to go into water. You have much more expertise in that area than I, so I'm sure you picked up on adequate information. But I am going to talk about the information pertaining to the DEC Part 360 permit. And I'm going to read this section because it's important for clarification purposes. The DEC cannot approve an application which is inconsistent with local zoning. The applicant sought an interpretation from the ZBA for clarification that the use was permitted. The letter by then Chief Building Inspector Hammond described the proposed operation as a C&D processing facility. When the applicant sought an interpretation from the ZBA, they asked specifically about a concrete crushing facility, which was later expanded to include processing of asphalt and earth. We now know the operation goes well beyond those activities. The engineering report supplied by the applicant for the required DEC Part 360 permit states, quote, and I know this was read before, but I'm going to read it again, "Pending approval, the facility will operate as a construction and demolition debris handling recovery facility that accepts concrete, asphalt, rock, brick, and soil for processing of mulch and RCA for sale." We did hear tonight that mulch was probably incorrectly included in that statement. That same report also makes reference to other transfer station-related activities. It is very clear, the zoning is very clear that transfer stations are not a permitted use. But my question is, why wasn't this language used to describe the operation when they went before the Zoning Board of Appeals? The ZBA's determination was based on limited information provided by the applicant. Understand, I am neither criticizing nor disparaging that determination, but merely asking whether, given a more complete and accurate description of the operation, if their determination would have been the same. As the lead agency, is it in your purview to ask the ZBA for further clarification that a C&D recycling and processing facility, as is more fully described in this DEIS, including the sale of processed materials, is permitted by town code at this location? Maybe a use variance is necessary. I'm not sure. And finally, the town is currently undergoing a comprehensive plan update, which affords an opportunity to examine the extent of industrial zoning in Calverton and the uses permitted therein. Definitive language on uses such as solid waste management facilities should be specifically addressed in our code so that these uses don't find their way into our town because of vague language. Because this statement is this statement is mischaracterized as my being anti-recycling. I will state that recycling must be embraced at all levels to reduce as many components of our waste stream as possible. However, it is to everyone's benefit, the applicants, the residents, and the decision makers alike, to have clear and predictable language to address these types of operations in our code and in our solid waste management plan. I thank you very much for your time and attention.
Thank you. Okay, anyone else from the public wish to speak tonight? Any statements or comments from anyone else in the public? Okay, so anything else from the board? No? Dick, if you could come up for a minute, please. Dick Ayers is the planning board's attorney.
Soon to be retired.
Soon to be retired. Myself as well. So, based on some of the information tonight, there seems to be some outstanding questions and some other information that's going to be submitted. Would it be appropriate for the board to hold this open so that that information and questions could be answered before we close this public hearing?
Certainly, if you're more comfortable with that. There's no requirement to close the hearing.
Okay.
So if you feel that the information that you've learned is not adequate for you to close the hearing, then you should keep the hearing open, receive that information, and proceed that way.
All right, there was a couple submissions that were going to be turned in, and there are a couple outstanding questions, so I think, for 2 weeks, I would recommend that we hold this open.
I think you might want to ask the applicant if 2 weeks is enough time for them to, yeah.
I believe Secret has a mandatory minimum of 10 days after the hearing, but that's a minimum. So if you want to reasonably extend that, that can be done. I would ask certainly my colleague, Mr. Malik, if he's concurrent, or you want to ask the applicant, they could work out with you for a reasonable time frame beyond the 10 days. That would be good.
I think what you're suggesting is that another hearing date, another public hearing date, or are you just suggesting that the record be held open for a period of time?
I think we want to have the record open so that we can get answers, get more information to the questions, and also the documents that were going to be submitted.
Right, but are you planning to hold another hearing date, or are you planning to give them a time to submit that material? In other words, do you plan to schedule an adjournment of this public hearing to the next date?
That's what we should do.
In one case, you're adjourning, I think what Mr. Seaman was talking about is the 10-day comment period, which is not an issue because that's required. If you would like to adjourn tonight's hearing for 2 weeks to receive the information, then the question would be to the applicant whether that's adequate time.
Yeah, I confer with the attorney. We think of something more like 3 to 4 weeks' time to get all these issues straightened out
Okay.
with the applicant.
So we'll adjourn it until the first meeting in December.
Okay.
I don't have a date, but it's the first Thursday in December. Okay?
Thank you.
Can we have a motion on that, please?
I think you should have a motion
Yeah.
on that,
Correct.
and they should, and publish that
Does
as well.
anybody know the exact date? Carissa?
Carissa, what's the meeting date for December, please?
Take a second.
I believe it's December 2nd.
Yeah.
December 2nd. I'm going to make a motion that Breezy Hill DEIS be adjourned until the first meeting in December, which is December 2nd. So moved.
Second?
All in favor?
Aye.
Opposed? Okay, so we're adjourned until December 2nd. Thank you, everybody.
Dick said December 25th, but we vetoed him.
Okay. Next public hearing on our agenda tonight is for 817 Pulaski Street. Greg, and I think Kim Judd is here, right?
Yeah.
All right, thank you, Mr. Chairman, members of the board. We're holding a public hearing on a site plan application which is seeking approval to construct a two-story self-storage warehouse with a footprint of 20,000 square feet, a total floor area of 40,000 square feet, and perform related site improvements including parking, landscaping, lighting, and drainage. Subject property is a 3.5 acre parcel of land located at 817 Pulaski Street in Riverhead on the southwest corner of the intersection of Pulaski Street and Marcy Avenue. And the property is located within the Industrial C zoning use district. We do have representatives for the application here. We have Kim Judd, the lawyer for the attorney for the application. We have Doug Adams, who's the project engineer, and I believe we have the project sponsor as well. So if the board has any questions, turn it over to them.
Okay, so we did have the applicant here for some work sessions, so the board knows what this project is about. So unless, Kim, if you have anything to add before I open it up to public comment, I'm not sure if anyone's here to comment on it, but.
So just briefly, the board knows that this is the former Agway site, and when we rolled over, this was Agway. I just wanted to point out, we did go and receive the zoning board of appeals variance last year. My client, Jim Matusky, who's here, I can tell you what I feel over and above what fines usually they don't want to go around and talk to the neighbors. Mr. Matusky went and met several times with Ziggy Walensky of Polish Hall and showed him the plan. He was happy that we were trying to emulate Polish Hall with the white and red. We still don't have any luck finding the red and white striped awnings. He met with St. Isidore's. They actually wrote a letter at the zoning board hearing, no objection. They went and they met with all the neighbors on Pulaski across the street from the Long Island Brewery. And then they went and met all the neighbors on the side of Prattville where the Quonset hut is. At that time, nobody had any objections. At that point, I don't know if there's anybody here tonight. My clients also met with the co-chair of the Downtown Revitalization Committee, even though this parcel is not located within the downtown revitalization area, just to show them what we were doing and allay any concerns that they may have. So if you have any comments,
Do you know if the applicant met with Heather McDowell? And we did receive a letter from Heather, I don't know if you received it,
No, I did not.
who's directly across the street apparently. What is the height of the existing building? This is going to be on the south side, correct?
Are you talking about the proposed building?
Yeah.
Oh, okay, here's the. Dean, do you know what the top? 32 feet. What's that?
It's a public hearing, so we'd like to get it on the record.
Okay, sure. This is Dean Gomolka, he's the,
Landscape architect. So the height of the building, the maximum height is 32 feet, and that's the towers.
Okay.
So you enter here, and that's these are stairways. That's max height.
Do we know the height of the building, the existing building in the front?
the Long Island Brewery. This is my client, Jim Matusky.
Hi, the existing brewery building is approximately to the ridge line is about 22 feet. So from Pulaski Street, if you're standing on Pulaski Street, trying to even look to the back of the tracks where the building will be, it's barely visible, about 8 feet.
Okay. All right, so as Ed had mentioned, this letter that we got from one of the residents, Ms. McDowell, will be part of the record. She's opposed to the project, just so it's on the record. She gave several reasons why. We could share it with you, but it will be part of the record.
I'll get a copy of it
Okay.
from your system.
We can have a copy.
Yeah, sure. All right, is there anyone from the public who has any questions or comments on this public hearing for the storage on Pulaski Street, proposed storage building? Anyone from the public? Anything else from the board?
No, sir.
Thank you.
Okay, motion to close?
Second, the motion.
Okay, Joe, you made the motion?
Yeah, I'll second.
George seconded it. So motion made and seconded to close the public hearing. All in favor?
Aye.
Aye. Opposed? Public hearing is closed.
Thank you. Good luck on your retirement.
Oh, thank you.
See you, and to Mr. Riley, good luck on your retirement as well.
All right, next item on the agenda is a discussion item for 794 Reeves Avenue. Is yours, Jeff? Okay. What do I do with that one?
Good evening, everybody. Jefferson Murphy for the record. We have received a letter from Thomas Kosikevich dated October 27th, 2021. He's requesting to construct a 40 by 60 pole barn building in the back of his property located at 794 Reeves Avenue, Suffolk County Tax Map number 600-143-1-1.4. His residential lot was part of a 4-lot subdivision approved back in 1990 that included 3 residential lots and 1 54-acre agricultural lot. The applicant owns that agricultural lot, and he farms that lot. The farm lot, the development rights have been sold to the county, and there is a 4-acre carve-out of that for a house and some storage buildings. What the applicant is seeking is to build the 40 by 60 pole barn building in his backyard of the subject property at 794 Reeves Avenue. And the question is, when the subdivision was approved, the planning board imposed a 50-foot rear yard agricultural buffer, quote unquote, and 25-foot side yard buffers. The problem is, they were supposed to file covenants for the agricultural buffer. It is assumed that the covenants were filed because the subdivision map was signed and filed with the Suffolk County Clerk. There is no copy of this covenants and town's record. The applicant cannot find or locate a record. And there's no notation in the planning board resolution indicating what its purpose and intent is. Of note with this, and this is a significant point, is that the buffer is located on the 3 residential lots and not on the farm parcel. And that point of distinction is an important one. If the buffer was located on the farm parcel, it is assumed that that buffer was there so the farmer would not disturb or farm that part of the property up against the backyards of the 3 residential lots. However, this buffer is on each of the residential lots, which, in my interpretation, based upon all the farm buffer documents I've ever seen in my career, is really intended to protect the farmer from any nuisance issues that may arise from farming, such as noise, dust, odor, that sort of thing, from any of the future neighbors of the residential lots. So it's for his own protection, I believe, that that subdivision map, that was Frank Kozak, as in Kazakevich, who is the applicant's father. So the question is, since there's no language or documents that can be found as to define what the purpose and intent of the agricultural buffer is, and there's the buffer is on each of the residential lots, it's being interpreted that as protection from the farmer, who is the applicant, that an agricultural or storage building within that buffer area could be interpreted to be allowed. And that's the question that's before you this evening. The applicant, Thomas Kazakevich, is here this evening. As luck would have it, the planning board attorney back there, back in 1990, is with us this evening. I don't remember what I was doing in 1991.
Now you know it's time to retire. So, this is a permitted building, and a building permit application has been filed for this permitted building. And the zoning and building administrator is here before you to seek some guidance as to whether this agricultural buffer would prohibit the issuance of that building permit. So you're not being asked to vary any zoning issues. You're just being asked to consider whether the purpose of that buffer would prohibit the agricultural building. And I can recall discussions on these agricultural buffers over the years. Farmers would spray their crops, make dust and general commotion, and that would antagonize the neighbors. And as a way to let the neighbors know that the farm was there before they were, the buffer was imposed to protect the farm from the neighbors. So,
Do with the right to farm as well?
well, there was right to farm. Actually, this might even be before the right to farm legislation. I can't remember when that came about. But my advice to you is that the purpose is to protect the farmer, and to the degree that he is the farmer and the farm use will continue to be the farm use, and that's the use that he's putting this barn to, that you could instruct the zoning and building administrator that it's appropriate.
Hey, Dick, is the property rights reserved behind it? They are, so there's never going to be a house there or anything. It's agriculturally preserved.
It's my understanding the development rights are intact, you know,
They were
are
sold.
sold, and it will be a farm.
Forever. Yep.
Now, the other 2 lots, though, lots 2 and 3 are not built on, they're just there, is that right?
No, the lot adjacent. The lot adjacent to it is owned by, or was owned until recently by one of the sons, and it was just recently sold by that son. And the third lot is not owned, is it still owned by the family? It's owned by a third party.
So how did the agricultural buffer get onto residential lots? How did it happen?
Just going back to that history, boundary lines we've had trouble, right, between,
No, I mean, I get with the dust and whatever,
right.
but, I mean, he's the farmer, how do you not let him build a pole barn
I
on
don't
his
think
own
it-
property, that he owns the property in the back?
Right, but it's on the map, the zoning building administrator has seen that on the map, you're the planning board, that's why we're here.
Who owns the buffer?
He does, the applicant.
So each lot owns the buffer to the north of their property?
It's on their property, the buffer is on their property.
Right. So
It's not north of their property, it's the
It's on the
northern
property.
portion of their property.
So each property owner owns that buffer?
Correct, the buffer is on their property.
It's on their portion.
Okay.
It's-
So I see on the one aerial on this lot, and your lot lines are on here, it looks like a structure, I don't know what that is, I can't make it out on this property that we have the,
Oh, the aerial?
yeah, the aerial.
That was a former pole barn, or a hoop house rather, that's gone.
That's gone? Okay.
Yeah.
Okay.
The other point I failed to mention is that this property is zoned agricultural preservation zone, and the location of the proposed building complies with all the dimensional setback requirements of the APZ zoning district. So if it wasn't for that agricultural buffer, we just issued the building permit.
So, and they still own farm the property behind it?
Yes.
Okay.
How would this affect other agricultural buffers? In other words, we setting some
You
sort
would
of...
be acknowledging that an agricultural use is appropriate in an agricultural buffer. I mean, I think that's basically the question. Is an agricultural use appropriate in an agricultural buffer? Would seem to be.
But we don't in this case.
Well, what would be your definition of an agricultural buffer?
So what the planning board was concerned about is if these homeowners put a swimming pool, let's say, and they were allowed to put the swimming pool in the rear yard setback that would be near the farm, and the farm use would have dust and whatever that would come over, and then they'd be complaining, gee, I built my pool next to this farm, and now the farmer's got to push his operation away from the boundary line. It was to push the farmer's boundary line toward to protect the farmer's boundary line as adjacent to the residential use.
And in this case, the farmer is still farming the property, and he still owns that lot that it's going on?
I believe he lives in the lot that it's going on.
Okay, so Lot 3 is not developed, right? It's still a buildable lot?
There's the house being built right now. There's a house being built right now.
Do you want to come up here, sir?
Yeah,
Come on.
if you could, please.
You know more facts about this than we do. I know the legal questions, but not the facts.
Hi, Thomas Kozakevich, 794 Reeves Avenue. I'm the one that filed the permit for the building, and the person that farms behind Lot 2. It's all mine. And the third lot, it was all family-owned. It was just sold, and someone's building the house right now on it.
Okay. And the barn that you're looking to construct, what is it going to be used for, and what's the purpose of it? I don't mean that, I just want to hear it from you.
Agriculture, doing stuff in it and working on equipment. I service all my own equipment and doing stuff, and it would just be more handy there, because in the wintertime, all our barns are full with all the equipment, and I
Right.
have no room to work on anything.
Okay, so it's going to be for your farm equipment and for your use related to you farming that property?
Correct.
Okay. All right, any other questions from the board?
No.
Okay.
So I think the zoning and building administrator is ready to issue the permit if the sense of the board is that that's appropriate.
Do we have to do a resolution at the next meeting?
I don't think you have to do a resolution. I think it's just wanted to bring to you this question so that it wasn't decided just by If you'd like to do a resolution, you
Well,
can.
how does our official decision get recorded into that? I mean,
Well, it's
for
in the
future-
minutes of the discussion tonight, but it's in the minutes of the discussion tonight, but if you'd like a resolution, we can certainly draft a resolution.
I think we should draft a resolution.
Yeah, I think so.
Draft a resolution.
Because I'm sensing that, we don't have an issue with this, but I think it should be worded in a way that if 5 years from now, the owner of Lot 3 wants to come and build something in their backyard that's not related to farm use, I think it would be a different situation. So I'm thinking that we should, capture this in a resolution and the reasons why we would be, approving it.
Fine, we'll draft one for you.
Okay,
Thank you.
all right, thank you.
Thank you.
You're welcome. Okay, next item, discussion item number 2. Captain and Falcone minor subdivision. 787 Union Avenue.
Thank you, Board. We have a two-lot minor subdivision application which we've received, which is seeking approval to subdivide an existing 5.43 acre parcel of land and create 2 separate building lots having proposed lot sizes of 1.83 acres and 3.59 acres. Regarding SECRA, the proposed minor subdivision application is considered a Type 2 action pursuant to Town Code, as the proposed minor residential subdivision conforms to the dimensional regulations for the APZ, thus requiring no further environmental review. The site is located at 787 Union Avenue, Aquabog, on the west side of Union Avenue, approximately 1,000 feet north of the intersection of Union Avenue and Main Road. The property is located within the Agricultural Protection Zoning Use District. The subject property is part of a prior subdivision. Back in September of 1984, the planning board at that time approved a subdivision known as the subdivision of Martin C. Nelson. This subject property was identified as lot number 3 on that map. That resolution did reference that there had been prior subdivisions of the parcel. However, the resolutions did not reference any names, and it's been difficult to research the prior history on that. However, at that time, it was treated as the board did consider it to be a major subdivision. However, they waived the requirements for the development standards of a major subdivision. As a part of that 1984 subdivision approval, it included a covenant stating that, quote, all 4 lots will never be further subdivided, and that the covenant was filed with the Suffolk County Clerk on all 4 lots within that subdivision. Subsequent to that 1984 approval, an individual named Donald Dennis petitioned the planning board by letter dated June 7th, 1985, to amend those covenants which restricted further subdivision of the properties, as the applicant desired to develop what was identified as lot number 1 in accordance with the new CR zoning use district which was in place at that time. The planning board, by resolution dated June 5th, 1986, authorized the chairman of the planning board to execute a modification of declaration of covenants to, quote, provide for further subdivision of same upon application to the Town of Riverhead Planning Board. The modification to the CNRs allowed for further subdivision. Application was made, was filed under the name Essex, Dennis, and Reeves. That subdivision was subsequently approved by the Riverhead Planning Board and created the current 4-lot configuration on the northwest corner of Union Avenue and Main Road. It's interesting to note because although the board did modify the covenants, the modification of those covenants didn't necessarily increase the allowable development that could have taken place on that subject parcel. As opposed to single-family residential lots where you're restricted to 1 single-family residence per building lot, commercial site plans are typically governed by such dimensional factors as building area, floor area ratio, lot coverage, etc. So chopping up lot number 1 of that property to allow for 4 individual owners didn't necessarily increase the amount of building that could take place, whereas if the board were to amend the covenants on this, you would actually allow for an increase in density. You would allow them to build additional single-family residential subdivision, single-family residences. In 2008, there was an application which was filed by Jorge Solorzano and Cayetana Quintero, which was seeking approval to subdivide lot number 2 of that subdivision. Lot number 2 is located directly to the south of the current parcel. The Planning Board, by resolution number 101, dated November 20th of 2008, denied the minor subdivision and cited the restrictive covenants as justification for denial. Public hearing was held on that subdivision on November 6th, 2008. A review of the minutes of that meeting indicates that there was an application made by a prior owner of that same subject parcel, which was known as East End Christian, which at that time was denied for the same reason. The minutes of the meeting indicate that a public hearing, Patricia Capon, which is actually the current applicant, appeared before the board to thank them for upholding the covenants. I did also, in the packets that I had distributed to you, I was able to find the resolution which denied that East End Christian subdivision, and there was actually a letter sent to Richard Ehlers, Esquire, who was the planning board attorney at the time, in January 2002. This is a letter from Phil Cardinale, attorney. He was hired by Patricia Capon and Les Falcone. He cited a number of legal reasons and legal questions and ramifications, questioning whether or not the board could even modify those covenants. So really what we have here is an application where an applicant is asking the board to amend covenants, which have been upheld twice and denied by 2 prior boards. They're now seeking approval to asking the board to modify those covenants and further subdivide the property.
So, back when this was first divided, I think you said it was considered a major subdivision?
It was a major subdivision in that it had been subdivided prior to that. Again, I couldn't find, to do the way the records are kept, the planning board waived the requirements for a major subdivision. So the major was just that it had been subdivided prior, and they came in again. It's kind of like a minor on top of a minor.
Yeah, that's what I have an issue with. You know, we keep coming back and doing these minors on top of minors. It's just like circumventing the whole process.
And that's why the covenant was put on, and that's why they agreed to it. The quid pro quo was, we'll minor this another time, and in return for that, you won't require us to build roads and infrastructure, and we'll agree it never be further subdivided.
And now they want to do it.
The person that didn't want it wants to do it.
Okay. Is the applicant here? Oh, Mr. Cuddy, okay.
Good evening, Charles Cuddy for the applicant. I want to take a few minutes of your time just to really review what happened. When you did these 4 lots years ago, interesting as was just pointed out to you, you had a road, so there was no road to put in. You had 5-acre lots, so you really didn't get too excited even about going to the health department. What was done at that time was very simple. We'll give up virtually everything and we'll get this subdivision done. I understand what has been said, and what has been said so far is that right after this was done, an applicant came in and the board set aside the first lot. I disagree seriously with Mr. Bergman when he says that lots are based upon the size of the site. The size of the site is exactly, that is the coverage. The size of the site is exactly important because RLC is this zone right now where the agency, the insurance agency is, and where the accounting firm is. That's 40,000 square feet, so I disagree with him that you can just decide that that was something that you could normally do. It wasn't something you can normally do. In 1984, the applicant got 4 lots. In 1985, he took one of those lots, or one of the board took one of those lots and broke it up. In 2008, the owner of Lot 3 opposed a change, but the opposition wasn't because the lot was bad. The reason that they were concerned was that the people who were going to break it up were going to put a school on the adjoining property. And so the owner that I represent opposed that. But she wasn't opposing breaking up the lot into two pieces. The reason she asked for this breakup is because her daughter needs a home to live in, and she wants 2 acres, which is the zoning right now, by the way, 2-acre site. And she would like to have 2 acres as part of her site, so her daughter can actually live here, and she's making a living in this area, but she doesn't have a place to live. So that's the reason for it. I don't think anything happens at all in this area, because if you look, and I have made a map for you, I apologize because it's just a rough map because it's 2 different sections, but I'd like to hand this out to the board. I think it's important that you see it. I put the map together because it's both Section 85 and 66 of the real property tax map.
Yeah, sure. Let me just look it over. I know you're here, Dick. Dick.
I have another copy if you need.
Thank you, sir.
My client's lot is the square that I have going around that comes out sort of with the flag coming out onto Union Avenue. Pointing out to you that above these 4-acre lots, there are 5 2-acre lots. One of them is actually 3 acres. Below it are the very lots that were broken out in 1984. Across the street, on the other side of Union Avenue, is a 45-lot subdivision with 1-acre lots in it. So changing this to 2 acres, to 2-acre lots, nothing is lost, because the area basically is either 2-acre or 1 acre. And all these people are asking is, can we have a place so our daughter can live in the town of Riverhead? She works in the town of Riverhead. I don't see that anything is lost whatsoever to the planning board by breaking these up. And to talk about having a covenant that was broken right away, but then wasn't broken again, for what reasons, I'm not sure. Doesn't make too much sense to me. This whole area certainly is a 2-acre area. It's an APZ zone. And yet across the street in the APZ zone is 1-acre lots. And to the north are 2-acre lots. So I don't see that there's a loss. The most lots that could be out of this entire site are 5 more. And that's all, no matter what you did with it. So it seems to me that it's not unfair to ask the board to take a second look at this, even a third look, and to say, yes, this is something that doesn't hurt the town. It's something that helps a family, as a matter of fact. And I would hope that the board would take a second look at it, and I certainly would hope that you would have a public hearing so that people could express themselves about it.
Okay.
I'd be happy to respond to any questions you have, but I think quite seriously that this is not a problem to break this up. And I know it wasn't done before, but I'm not sure that those reasons exist anymore. And it's been 37 years since this subdivision was started. And again, it was broken immediately. And then it was supposedly not the right thing to do 13 years ago. But 13 years have changed, times have changed. People need land to live on. And that's what this application's about.
The present zoning is 2-acre.
This is 2-acre now. The entire area around it is 2 acres.
Greg, would you be able to answer, like when the planning board waived the conditions of a major subdivision, What was forfeited on the town's part?
So, I mean, a major subdivision is typically, when an application comes in, you have areas for road dedication, drainage dedication. The way the parcels are originally configured, when there's sufficient frontage on an existing town road, again, I can't speak specifically to that prior application, but, if there was let's say you had 12 acres that fronted on a town road in a 2-acre zoning, hypothetically, they could get 6 lots of it. If they all front on a town road and there's not really a need to build out additional roadways or, cul-de-sacs, if the lot would lend itself to just have frontage and be served by existing infrastructure, I would think the board at that time could waive the requirements for a major subdivision.
What is the zoning there now? Is it agricultural?
Yeah, it's located in the
It's
APZ.
agricultural all around.
Yeah, I mean, it's APZ zoning, minimum 2 acres. There's no question, what their application proposes, it complies to the dimensional requirements of the APZ zone. I do agree with Mr. Cuddy's, position that it's not really trying to subvert the existing zoning. It's nothing, save for these covenants that wouldn't be allowed under the current zoning. It's just that there's a history of the planning board upholding these covenants. You would, as Mr. Cuddy stated, and I did note in my report, the board could be setting precedent for those other subdivisions. You could be, hypothetically, for those additional lot numbers 2, 3, and 4, you could be looking at an additional 5 single-family residences, along that road. I did note that the property is not located within the Riverhead Water District. That may come into play down the road when they go to get health department approval. There is a 12-inch water main which is installed in Union Avenue, but those properties on the west side have not been incorporated into any water district.
All right, what's the board's feeling on this? I mean,
I don't like setting the precedents.
Yeah, I'm a little concerned about that myself.
It's all agricultural there. I mean, the big subdivision was done, yeah, and everything is all, it's all the way down towards Main Road. As soon as you pass up through there, that's all agricultural. This person was adamantly against it, now they want it. I mean, he explained
Agricultural
that.
is to the, I guess it's the west side of the lot. I mean, everything else that Charlie shows here, except for the 1 6-acre lot that's standing there, has already been carved out.
You do it on this one, the other 5 can come up.
all right, so, I mean, I'm not hearing support from the board on this. Dick, what do you agree, or?
I'd like to leave it alone.
Okay. So we're not inclined, unfortunately, we're not inclined to move forward with this right now, Mr. Cuddy. I mean, if there's anything else compelling from you or your client that comes forth in the near future, feel free to bring it back to us. But at this point, the board doesn't want to set a precedent.
Excuse me, like Mr. Ellers, I've been here a fairly long time. I don't think that this sets a precedent for anything. I think this is unique to this particular site. I don't know of any other site like this, or at least I haven't come in contact with another site like this. So I think what you're doing is you're saying we're looking at something that actually has virtually no impact on the community, because the community already has a density double across the street. So I don't see that this is something that's going to set a precedent for anything except to this particular site.
The people with the homes around there know that that piece is not going to be built on or subdivided, and they probably bought their property knowing what the surroundings were. So I'm a little concerned about breaking those covenants.
You mean the people, the 45 lots across the street?
No, the people,
No, there's 2 lots.
This house is up right up Union Avenue that are not part of the Grant Avenue subdivision.
Yeah.
And they're directly across the street from there, and adjoining and abutting that property, by the way.
There's a 5-acre and a 6-acre lot that are still there.
There's
of
two
those
little
lots.
right in front.
Could then come in and ask for subdivision as well.
Well, I'm talking about the entire 3 lots here. I'm not just talking about this lot, because I understand that would happen. I'm saying to you, the most that you could get is 5 acres, and I think Mr. Bergman agrees, 5 separate lots, but they'd all be 2-acre lots. So that's why I don't see that you have anything that the community's being hurt by. And the zoning for the whole area is 2 acres. So what I was asking for is that the board have at least a hearing so that people could express themselves, because I don't think you're going to find that people are going to be opposed to what we're asking for.
Well, it doesn't, I mean,
Now-
at this point, you just don't have the support from the board. I mean, I can have a conversation with Dick, just so we, better understand what the potential is here, good and bad. But at this point, I think we're just going to stand firm on it.
Well, I would ask you to reconsider, but I think, again, that this only hurts somebody in the community who's working here and trying to find a place to live. And that was the reason for the application, by the way.
Okay. Thank you.
So just in terms of procedure, I do have a question for Dick. I did note that when the subsequent subdivision came in, I believe it was the Solorzano Quintero. Again, the board did hold a public hearing on that application, so I'm not sure if a public hearing would be required. I believe the board would have to act one way or another, either in the affirmative or to deny the application. And I'm not sure, I would defer to Dick if a public hearing would be required, because it is a subdivision application that has been submitted.
Right.
So we're back to one of those basic questions. Do you have the jurisdiction to consider something that's not permitted? And you can choose to consider something that's not permitted and then determine to alter, in this case, the covenant and permit it, but on its face, it's not permitted. So I think you would be on firm territory to say, we vote to reject the application because it's not permitted without the hearing. But you may, if you wish, choose to have a hearing if you feel like you'd like to have more information.
Should that be done by resolution?
And if you'd like time to think about it, you could do that as well.
Well, I'd like to at least put it off to the next meeting, but would we need to reject it as is? Would we have to do a
You
resolution?
need to do a formal action to act upon the application.
Okay, so we will put it off to the next meeting.
Do we want a resolution at the next meeting?
That's what we've agreed to, that we're not going to.
So we have to let staff.
Right.
Right, but are you going to want a resolution to summarily deny it based upon the covenant? Or-
Yes.
Yes, okay.
Yeah, I don't see the sense of having a public hearing if there's no support of the board. I mean, what's the purpose of that?
We'll draft such a resolution.
Okay, thank you. Okay, the next item, Riverhead Chrysler Dodge Jeep Ram application amendment.
All right, so we've received a site plan amendment application which is seeking to make changes to an approved final site plan to establish a new car dealership and related site improvements. That final site plan was granted by Planning Board Resolution Number 21-002, dated January 7th, 2001. The specific amendments to the final site plan consist of the following changes. They've slightly revised the size of the building. They've reduced it from 31,146 square feet to 30,543 square feet. Building elevations have changed, and the location of the building is in approximately the same location. They're going to proposing to relocate the hot box from the building front yard walkway to a planting island on the west side of the front yard. Relocate a dumpster location, install 6 electric vehicle charging stations, change the size of the drainage rings from 10 foot to 12 foot in order to comply with the SWIP requirements, change all asphalt pavement from pervious to impervious, add a flagpole in the front yard, and reduce the total number of parking stalls from 175 to, I believe, 172 to accommodate the installation of the RPZ. The proposed site plan amendments are an enlisted action pursuant to SECRA, with coordinated review being optional and not recommended. Staff recommends the planning board assume lead agency and issue a negative declaration, as the proposed amendments are minor in nature and are largely consistent with the negative declaration which the board adopted by resolution number 19-69 dated August 1st, 2019. As a result of the change from pervious asphalt to impervious, the application did require relief from the Zoning Board of Appeals for exceeding the allowable impervious coverage by approximately 6,400 square feet. They did receive that relief from the Zoning Board by appeal number 21-32 dated August 12th, 2021. A public hearing was held on the preliminary site plan application when it came in previously. That hearing was on June 6th, 2019. At that meeting, no members of the public came forward to present any concerns or objections to the proposed project. As the proposed modifications are minor in nature and there was no public input on the application, staff recommends the amendments be handled administratively and not require a public hearing on the amendments. The application was reviewed by the ARB at its October 27th meeting, at which time it received approval from the ARB. The town engineer will require an amended SWIP application due to the change in the size of the drainage structures as well as the change in impervious surface coverage. The applicant has submitted that and they are working on it through the engineering department. So I did list on page 3 of the staff report, I just indicated a number of the conditions I would have included in the approval resolution, all to be satisfied prior to the issuance of any building permits.
Between the time that you granted the original and this time, have they done any work on the site at all?
I believe they've demolished an existing building, but I don't think they've performed any other major site work. Is that correct? Yeah. They're not, yeah, the batting cage is in another building they took down.
So the change from pervious to impervious, I assume that's the reason why they're increasing the drainage rings to comply with the SWIP?
I believe so, yes.
All right, and the condition is they have to satisfy the town engineer, right?
Correct, yeah. They will need an approved SWIP before any building permits can be
Okay.
issued on this.
All right. I don't have any issues with that. Anybody?
No, good.
Okay, so administratively is fine, Greg, thank you. Okay, next item on the agenda is 313 West Main Street, LaSala office site improvements.
All right, so this is an existing site plan application that it's been hanging around for a little while. I have spoken with the applicant. This is to perform site improvements at the location of an existing office building on 313 West Main Street, including parking, stormwater management, a widened curb cut on West Main Street, new landscaping, handicap accessible ramp, as well as a freestanding sign with a landscaping bed. Proposed action is an unlisted pursuant to SECRA, coordinator review being optional and not recommended. Staff recommends the planning board assume lead agency and issue a negative declaration as the proposed site improvements to an existing office will not have any foreseeable negative impacts. The applicant had been working with the New York State DEC. They had been working for a while to get their plans approved. The applicant did submit New York State DEC permits. They got a Article 24 freshwater wetlands permit, which is valid September 9th, 2021 through November 7th, 2024. And they got a wild scenic recreational rivers permit, again valid September 9th, 2021 through November 7th, 2024. The applicant to date, when the application was last reviewed by the board, they showed a parking plan on the west side of the building. On page 3 of the staff report, I did note that there's a large mature tree located on the west side of that building. The applicant did provide a revised plan where they're going to retain that vegetation. They are going to slightly reduce the number of required stalls. Based on the size of the building, the site requires a total of 11 parking stalls. Based on their parking plan, they're going to provide 8. There is a mechanism in the town code, it's section 301-231L, which gives the reviewing board basically discretion to allow for land-banked parking, provided that a total of 2/3 of the required stalls are provided. They do meet that minimum 2/3 that they are providing. If the board is amenable to it in order to retain some of the vegetation on site. However, that section of town code does require that a legal instrument would be filed on the property, which would require the applicant or the property owner to build out that required parking, the full parking, upon subsequent finding by the board. In other words, if the board found that the site was congested, people were parking on the street, et cetera, they could come back at a later date and require the applicant to build out that full parking. Staff has no objection to allowing the reduced parking. Right now, the site is operating. They are using the office. I drive by every morning. They are parking in the back of the building. Doesn't seem to be a huge issue, so if they could have some parking in the front, it would seem to just alleviate any of the issues. The applicant is working from the New York State DOT to get a permit from them. The application is actually on for the Conservation Advisory Council next Wednesday. So I do have an administrative approval resolution here, which would be contingent upon obtaining the New York State DOT permit for the proposed work within the state right-of-way, obtaining Conservation Advisory Council approval, as well as the filing of a legal instrument which would require the build-out of the full parking upon subsequent finding by the planning board.
Okay, any,
Are you satisfied with the parking situation?
Yeah, I mean, in the, in the spirit of trying to retain some of the large existing vegetation on site, my opinion is I think it would be more appropriate to allow a reduced parking. Again, if it's found to be an issue, the board could come and make a subsequent finding and require that full build-out. But, it would be a shame to cut down that tree if it's not really necessary to do so.
is that going to be listed as a condition?
Yes, it would be. That would be the covenant and the legal instrument that would be filed. I've yet to work on one, but we can work with the town attorney's office to get some language just to facilitate that covenant.
Okay, I'm fine with the administrative on this one. Anyone object? No? Okay. All right. They're all yours from here on in, huh, Greg?
Yeah.
Will we get you any help soon?
We're trying. We're trying.
It's been a while.
Yeah, we had made some offers and they turned down, but we're working on it. Until then, we'll just keep chugging along.
Okay, next item, Norfolk Developers Major Subdivision.
All right, so this is just a quick update. We do have a major subdivision we're considering for a 10-lot major subdivision. The planning board held a public hearing on this application. I believe it was held on September 2nd, 2021. Just a brief history, they did receive yield map approval for an 11-lot yield. Subsequently, the board approved a 10-lot sketch plan. The applicant voluntarily reduced the development density from 11 down to 10 lots. That eliminated the need for the applicant to comply with the Long Island Workforce Housing Act, so they didn't have to provide any affordable housing on site or any kind of payments. Planning board completed SECRA on the application on June 17th, August 5th, 2021. We did receive comments. This has been reviewed by Vinnie Gaudiello, the town's consulting engineer. In the resolution, I did include comments from October 5th as well as October 20th. So we have a preliminary plat approval resolution, which is subject, there's a number of conditions. I'll just read through them very briefly. Preliminary plat is subject to the following conditions. There is a permanent drainage easement along lot numbers 4, 5, 6, 7, and 8 of the subdivision that shall be provided to the benefit of the Town Riverhead Highway Department. This easement area shall remain undisturbed in its natural state. No structures or improvements shall be constructed within this easement, with the exception of any improvements deemed by the Highway Department to be appropriate and necessary for stormwater management purposes. Any improvements in this area will be installed solely by and at the discretion of the Riverhead Highway Department. That the earthwork data on sheet 2 of 5 indicates the project will require an excavation and exportation of 3,799 cubic yards of material. As such, an excavation permit will be required from the town board prior to the development of the site in accordance with section 229-3 of the town code. And that prior to the issuance of any building permits for the development of any residential lots within the subdivision, an engineered grading and drainage plan shall be submitted for each lot and reviewed and approved by the town's consulting engineer or his assign. This condition was put in due to the grade changes that are present on most of the lots within the subdivision. There are a number of conditions that need to be satisfied prior to the consideration of a resolution for final plat approval, which includes getting an approved stormwater pollution prevention plan consistent with the requirements of the code. The applicant must have the proposed lateral water main extension approved by the Riverhead Town Board. They need to get health department approval, speaking to the performance bond estimates, language for the temporary grading and drainage easements, language for the permanent drainage easement, as well as the common driveway easement need to be submitted. They need to make one minor revision on sheet 1 of the plans, which says workforce housing option, as this is no longer valid for this application. The building envelopes shall be removed from the maps, and the town engineer shall review and approve the proposed street lighting plan in accordance with town code. So we've had a thorough review on this application, and we're here for now preliminary plat approval.
Thorough was the word for this one.
Yeah.
Just beat to
Greg,
death.
I had one question. We had a discussion this morning. Has the resolution, has the applicant or has Doug Adams seen the resolution?
I sent it to the applicant, Gary Sherman.
So he's aware of the comments that Vinnie Guardiello made?
Yes.
That are in there? Okay.
When we had the public hearing, we had a Mr. Johnson come here, and he spoke very passionately about, the possibility of a park or the developer reaching out to him. Did anything happen in that regard?
So on this, the application, we do have something from the Parks Department. The plan was referred to the Parks Department. And it's kind of a consistent comment that we've gotten from them. Rather than have like little pocket parks set aside throughout the town, the Parks Department would rather have the $3,000 per lot fee in lieu of providing parks. In discussions with Mr. Coyne, it's just additional time, additional labor to maintain these parks and keep them up. And they've found that it would be better suited to take the payment in lieu of providing a park.
Well, okay, but it's not being responsive to the community. And what about maybe we're not at that point yet, but the water district having the ability to serve this?
Well, that's a town board action. The applicant has engaged with H2M architects and engineers. I know they are working on a map and plan. That would be up to the town board to approve that water district extension.
No, I understand that, but if we're approving something that they may not have the capacity, we're adding to a problem. We've been through this 100 times. So, I mean, I understand it's the town board's jurisdiction, but it's like them approving special permits, and then we have to deal with all the comments from the public. It's that in reverse.
The only thing I can say is that the applicant, when they initially contacted H2M, I believe the letter was from November 2019. There was a comment in that letter, it detailed the plan, it detailed the process for obtaining a water district extension. And the applicant was notified in that letter that there is no guarantee that the property can be served. So they were put on notice.
That came from the water district?
That came from H2M architects and engineers.
There's no guarantee that the property can be served? Okay. All right, as long as they're aware of it. Okay, any other questions on this?
No.
All right, thanks, Greg.
Not going anywhere just yet.
Right. Yeah, well, I don't know if the health department would allow that, but.
That becomes a real argument.
Okay, next item, Digger O'Dell's, another administrative site plan.
All right, so this was an application that Brian Cunningham was working on before he left employment with the town. It's an application seeking approval to construct an outdoor seating area to the rear of the existing restaurant space at 58 West Main Street, which is currently operating as Digger's Ales and Eats. It's also a shared backyard. There's egress, I believe, from the brewery located on the corner of Griffin and Main Street. The Planning Board did classify the action as a Type 1 action pursuant to SECRA because it is located within the Riverhead Historic District. That was done back in March of 2021. To date, no objections have been raised to the Planning Board's request for lead agency. So we do have in the resolution, Planning Board would assume lead agency and issue a negative declaration. Proposed improvements to the site include putting a 6-foot tall black aluminum fence with two 48-inch wide swing gates with panic hardware along the northern property line behind the building. The plan shows a total of 40 additional seats outside. Stormwater management systems will be installed, including a French drain and leaching pools. And a new steel or aluminum exit stair will be installed, as well as a handrail to allow for egress from the second-story dwelling unit. All exterior lighting will be converted to full cutoff, dark sky compliant lighting. And I do note that previous versions of the plans called for installing landscaping within the town-owned parking lot. These improvements have been removed. There is no work proposed in the town parking lot, so they do not require additional authorization from the town. Planning Board, this is not really a major application. I do recommend the administrative approval for this, subject to the conditions that prior to the issuance of a building permit, they must obtain approval from the health department for the increase in seating capacity. It needs to get a fire marshal permit to ensure fire safety, fire service access to the site. That's it.
Yeah, so that was the issue that we had talked about, the landscaping that was within the town parking lot, and you said that's been rectified.
Correct. They
Okay.
removed that, so now there's no additional approvals from the town.
Okay. Any questions on this one? No. Okay. All right, Greg, the last one, Browning Hotels, minor subdivision.
So this, we just have a resolution for a two-lot minor subdivision. Applicant is seeking approval to subdivide the property located at 2012 through 2038 Old Country Road, which is currently improved with the Hilton Garden Inn and the Marriott Residence Inn. They're seeking to just subdivide the two properties so that he can sell an interest in one of the hotels. The subdivision application required a change, I believe it was to impervious coverage and contiguous landscaped areas. The applicant received that relief from the Zoning Board of Appeals by determination dated September 9th, 2021. Planning Board held a public hearing on this application on July 1st, 2021. Planning Board, we did secret determination on that, as well as the site plan that they have going on. So we do have an approval resolution, subject to the following conditions. Cross-access agreement between lot numbers 1 and 2 of the proposed subdivision in a form approved by the Town Attorney's Office or Council of the Planning Board shall be filed with the Suffolk County Clerk, and the copy of the cross-access shall be filed with the Town Clerk and the Planning Department. A reciprocal parking agreement between lot numbers 1 and 2 of the proposed subdivision, which shall allow for unrestricted use of the parking facilities for the guests of either hotel, again in a form approved by the Town Attorney's Office or Council to the Planning Board, again filed with the County Clerk, as well as the Town Clerk and the Planning Department, and receiving Health Department approval for the proposed subdivision. And that's it.
All right, so this is just splitting up the parcels
Just
that are
splitting
already
up the
there.
two
because he
hotels,
wants to
yeah.
sell
Again,
one of them, right?
As long as the cross-access and the parking agreements are in place, it's really no change to the actual site.
Okay, any questions on this one? No. He's been here a couple times, too.
Yeah.
All right. Thanks, Greg.
That's it.
How many hours a week do you work? All right, thank you. So any public comments on resolutions before we vote on the resolutions tonight? Any public comments? None of the students have any comments for the resolutions? Come on, you get extra credit if you come up.
I want to watch a Jets game.
All right, resolutions.
I'll move resolution number 106, approve two-lot minor subdivision of Browning Hotel.
Second.
Okay, motion made and seconded to approve Resolution 106, subdivision for Browning Hotel properties. All in favor?
Aye.
Aye. Opposed? Resolution is approved.
I'll move Resolution 107 for North Fork Developers LLC. So moved.
Second.
Motion made and seconded to approve Resolution 107, Norfolk Developers for a plat approval preliminary. All in favor?
Aye.
Opposed? Resolution is approved.
I'll move Resolution 108, Riverhead Chrysler Dodge, for the site plan amendments. So moved.
Second.
Motion made and seconded to approve Resolution 108, Riverhead Chrysler Dodge administrative approval. All in favor?
Aye.
Aye. Opposed? 108 is approved.
Resolution 109, 313 West Main Street, LaSalle Office Site Improvements. Resolution granting administrative approval for site plan application proposing site plans at the site of the existing office building.
Second.
Okay, motion made and seconded to approve Resolution 109, 313 West Main Street administrative. All in favor?
Aye.
Aye. Opposed? Resolution is approved.
Move resolution number 110, which is an administrative approval for Digger Odell's outdoor patio expansion.
Second motion?
Okay, motion made and seconded to approve Resolution 110, Digger Odell's administrative for outside patio. All in favor?
Aye.
Aye. Opposed? Resolution is approved. Okay, any comments from the public on any matter in front of the planning board? Anyone from the public?
Hello, Taffy Turchin again with Calverton Civic. I have a request or a clarification on the notice for the hearing for today for Breezy Hill and for the one for December 2nd. Are those notices, the 14-day notices, not only in ENB, but also in a local newspaper?
They have to be reposted, I believe you said, right, Dick? Yes.
So were they done for today?
Yes, everything was done for today. Our secretary informed me that before the meeting.
And just out of curiosity, I know that there was a previous hearing this summer where Newsday was used on a 10-day type of notice thing. And my request would be that we use the Riverhead newspaper of record, which is the News Review, which is more likely that folks in the area will be reading that versus Newsday, and that'd be the full 14 days. That's
Okay,
it.
thank you. Okay, minutes from October 21st.
Move the minutes of October 21st. So moved.
Second motion?
Motion made and seconded to approve the minutes from October 21st, 2021. All in favor?
Aye.
Any other business?
Jet skiing.
All right, next meeting is Thursday, November 18th at 3 p.m. Motion to adjourn.
So moved.
Okay, have a good night.
Happy Thanksgiving.
Nice weekend, everybody.
Not yet. We got a little early.
Not yet.
Oh, he's going to Florida.